A very good morning to all. I welcome everybody in today's function, lecture. We are delighted and honored to have with us Mr. Amit Desai, Senior Advocate, who has agreed to give a talk and lecture on the new statutes that we have. This will be a function which will be recorded and subsequently uploaded on our YouTube channel. May I request our President, Mr. Nitin Thakkar, to kindly come to the podium and address our members, and welcome Mr. Desai in our midst.
Good morning, everyone. Thank you very much, Mr. Amit Desai, for agreeing to deliver an overview of Bhartiya Sakshya Adhinayam. All of us will have to get used to these new names: Indian Evidence Act, Bhartiya Nyaya Sanhita, Indian Penal Code, and Bhartiya Nagrik Sanhita, Code of Criminal Procedure. I don't know what is the relationship between Nagrik and Criminal Procedure Code. Then thank you to all of you for having come here at 10 o'clock in the morning on a Saturday. That shows that all of you are really interested to know what are these new acts and what is going to be its effect. I don't want to be between you and Mr. Amit Desai. I think everybody is eager to listen to him. But I must share this, that when I called Mr. Amit Bhai that we want to arrange this and we will do it for 3 hours and all the 3 acts must be covered in detail, he advised me, it is too early to cover all the 3 acts in detail. Let us give an overview just now, and later on, once government decides to bring this acts into force, we will do it, each act separately, and we promise Bombay Bar Association that we will do it separately on each act at a later date. But just now, let us wait for Amit Bhai to give us overview of all the 3 acts. Thank you very much.
Thank you, Mr. Thakkar. May I now request our member, Mr. Sushant Matre, to kindly present to Mr. Desai a small token of our affection. And may I now request Mr. Desai to kindly come to the podium and begin with today's lecture.
So, Nitin Bhai, Vishal, esteemed colleagues, esteemed juniors, well, thank you for having me here today. And my apologies to all of you for pulling you out at 10 o'clock in the morning on a Saturday, which is, I think, contrary to the norm of the Bombay Bar Association for these programs, which are normally at 10:30. But I had expressed to Nitin Bhai some personal difficulties, so he has been kind enough, and I'm very grateful for all of you to even come in so early on a Saturday morning. So as Nitin mentioned, today is not a day to go into this statute in great detail because it's not yet notified and we are not sure as to when it will actually be notified. There are versions in the media that you would have read that it might happen later this month, and then some say it will happen probably after 4 or 5 months. But in any case, provisions can be notified over stages, and my own sense and belief is that it will take a little while before these acts are actually notified and brought into force. So let me therefore today just spend a little while giving you a little overview and, sorry, not audible? I must confess that generally I am told in courts that I am so loud that I am audible in the adjoining courtroom. Well, so as I said, today is obviously only a day for a little overview, and as all of you bright minds will keep analyzing these provisions as we go along. I'm sure that you will have many questions, a lot of confusion, and probably give you the opportunity to start evolving new principles in relation to this statute. So, with that little caveat, because obviously nobody knows what this is going to be, let me give you a little broad background first, as a very broad overview of what I sense about this legislation. These legislations make an attempt to be progressive. These legislations should be progressive, but I think they fall short of what really is necessary for the next 50, 70 odd years of the criminal justice system. But it makes some attempt, as you will see here and there, but I still believe it should have been done. But what I do find is a little shift in the approach that we now see in the criminal justice system. And what we find is that punishments have increased significantly in many provisions. Death penalty, as I'll tell you a little later, has been increased in many offenses. And we also have life imprisonment till the remainder of your life added to many additional offenses. I think it gives you a sense as to where the government believes we are going as we move forward, that one would have thought that by now we would have a reformative process and punishments would be actually a little more balanced. But what we are seeing here is more serious and aggressive forms of punishment. So that's something that to be assessed as you will see the broad approach to this legislation. And we also find, of course, one positive, which is that there are more provisions for victims' rights as compared to the earlier CRPC. So let me give you a little history about the criminal justice system and how we had actually moved. So, sometime in the early part of the 19th century, it was noticed that the penal laws and the procedure code in this country was extremely divergent and a motley form of very unprecise provisions and procedures, because we had different provisions which applied to presidency towns like Bombay, Calcutta and Madras, and we had different rules and procedures which were applicable to mofussil areas and princely states. So, in the early part of the 19th century, an attempt was made to start a process of codification of all these laws to ensure that all over British India there is consistency of laws in relation to both the crime and the procedure. So the first early part of endeavor was undertaken by the legendary Lord Macaulay, who started this process with the Indian Penal Code. And he started this process in 1834, and it took him 3 years to prepare the first draft bill, which was ready in 1837. But the interesting thing is that that was only the first draft, and this draft underwent many revisions. And it took another 26 years with the assistance of Chief Justice Peacock, who fine-tuned this bill, and ultimately the bill was ready to be promulgated in 1860. So you can imagine 29 years to arrive at this, what was known as one of the best legislations in many ways across the world in penal law. Simultaneously, around the same time, we saw a process of the codification of the procedure code. So the procedure code codification began sometime in mid-1800, and they experimented with various versions and came out with the final version in 1898. But to get to that stage, it took them nearly 40 years. to find a code of 1898, which was, according to them, now reasonably balanced to deal with the rights of parties. 40 years. And the Indian Evidence Act, the process began, in fact, in the early part of the 1800s, because the rules of evidence were very, very vague, imprecise, and in many ways, at Mofussil areas, there was a lot of ad hocism as to what is admissible, what is not admissible, what is relevant, what is not relevant, etc. It would go virtually based on what the judge would feel, the Qazi would feel about what should be allowed and what should not be allowed. But this process of codification took nearly about 50 years so far as the Evidence Act is concerned, and we then had the Evidence Act of 1872. The interesting situation that you would see is that from 1860 till 2023, we really never had a need to modify or bring in a new legislation so far as the Indian Penal Code is concerned. So it has stood the test of nearly 200 years. Indian Evidence Act also has stood the test of time from 1872 till today. And it was only the CRPC which underwent some changes as a procedure code. And we've had, in these 125 years, we've had this as the third act, because the 1898 code was repealed with a new law in 1973, which was about 75 years later. And now, 50 years after that, we have the new act, which we are now going to talk about. And the interesting thing, again as a small factoid, is that we are on the verge of the golden jubilee of the Criminal Procedure Code, because on the 25th of January 1974 it came into effect. So we are fortunately just 5 days away from the golden jubilee of the CRPC, where we have a new act in place. So we struggled, as Nitin Bhai says, with the titles. And we all probably part of the city in which we live, where we are more familiar with English. And we have to therefore now learn what some youngsters used to come in and tell me, that these are tongue twisters. And we've got to learn to now make sure that we can pronounce it right. But the more important issue for me is the subtleness with which you see a little shift in the approach of the government when it comes to criminal justice system. When you actually think about the titles which have been given to these bills, I think it gives you a sense of direction of where the criminal justice system is now moving. So you have the Bhartiya Nyaya Sanhita, which is the substitute for the Indian Penal Code. And you sit back and think about what is actually the meaning of Nyaya Sanhita. And the Nyaya Sanhita, actually Nyaya is justice, and Sanhita is a code or a compendium. So you're talking about the Indian Justice Code as against the Indian Penal Code. So the Indian Penal Code was all about punishment of the offender. And today you now have a law which says that this is a code for giving justice to the people. So that's an interesting sort of indication as to the approach of the government of the day in the context of criminal justice system. You think about the other legislation, which is the Bhartiya Nagrik Suraksha Sanhita. Nitin rightly asked, what is it really intended to be? And I've struggled with it when I saw this title. So if you take the meaning of Nagrik Suraksha, it's about protection of the citizen. So you have a procedure code which is the Indian Code for Protection of Citizens, Nagrik Sanhita. So once again you get a sense that what was a procedure code to deal with mere procedural aspects of a criminal proceeding for in the criminal justice system. Your title gives a sense that we are now dealing with protecting the citizens through this code. And when it comes to Sakshya Adhinayam, the Sakshya Adhinayam is more or less in line with its literal meaning, which is the Evidence Act. So when you will yourselves analyze the provisions in great detail, keep looking out as to whether you find a correlation between the underlying provisions and the title to the legislation. Now, whilst we see this trend, and we will all argue in courts, intention of the legislature, meaning to be given to the title, meaning to be given to the title with reference to the provisions, all this will be argued as we go along, and we will wonder where it goes. Are we seeing a transition from what we thought was a relatively progressive, balanced legislation towards a legislation which enhances the powers of the state and the powers of the victims in relation to the criminal justice system, and shifts the goalpost a little bit away from the balance that might have been there? And in the 75 years of our Supreme Court, you will find that the courts have actually used 21 again and again and again and again to balance the rights of accused and victims equally. And that is really the flame which has kept all of us going in the criminal justice system, because ultimately in this system, what do we fight for? We fight for an accused's rights to a fair trial, to a speedy justice, to have been prevented from the abuse that a state may wreak upon an individual accused. That's what we fight for at the end of the day. But one has to see, because that's how 21 really kept that flame alive for all of us. But the flip side is that in this entire process of, in the period of, whilst 200 years ago, it took anywhere between 30 to about 40-45 years to prepare an outstanding set of legislations. In the present context, the legislations have taken probably about 2 to 3 years to draft, for 4 months between presentation and promulgation. 4 months. I don't know whether it's linked to the fact that what they ultimately did in these 3 legislations is that the 3 legislations actually cover about 1069 sections. And in these 1069 sections, when you sit back and actually look at it, there are probably only about 35 or 40 new sections, maybe even less than 35 sections, new sections which have been added. And there are amendments to roughly about 150 odd sections, some major amendments, some minor amendments which I'll touch upon very briefly. But so out of about 170 sections, we've only had this significant change. And so at the end of it, when you sit and reflect, these 3 legislations in many ways, and particularly the Indian Penal Code and the Indian Evidence Act, because most of the changes have happened in the Nagrik Suraksha Sanhita, but in those 2 bills and acts, the number of sections which have been altered is not more than about 12 to 13. That's it. Now, when you sit back and reflect, you then sit and think that the gentlemen who sat and prepared those acts in the 1800s were legal engineers with their ability, vision, quality of language, were able to think of a draft which stood the test of nearly 200 years. Because even today the government of the day believes that virtually about 80 to 85% of the acts, and particularly in IPC and in evidence, virtually about 95% of the act is still the same. There's hardly any change except for the title. So we have to compliment and credit the legal engineers of that year. It's not about them being British, it's just about their approach, their analysis, their critical thinking, their vision, their command over the language, which really has stood the test of time to the stage at which we are today. So with this little contextual background and little factoids, let me give you a little sense of where the changes are and what their possible implications are. Let me take the Bhartiya, Nagrik, Suraksha, Sanhita first, because that's where there is a maximum change. So this particular statute actually is supposed to be essentially in three parts. It's what I call the triumvirate: personal liberty, speedy justice, and procedural fairness. These are the three essential tenets of this particular act, which is what it's meant to be. Its intention is obviously to bring balance between the victim, the investigating officer, the accused, and the justice delivery system, the judge. So if I take some of these broad heads and give you a little flavor of what are the little changes that have started happening, let me take personal liberty as the first head. In the context of personal liberty, for all these years, we have grown up with the principle that when an accused is arrested, he is produced before a judge within 24 hours of his arrest, and then he is entitled to be remanded to custody. And the question is, what is that period of remand to facilitate a good investigation that he should be granted? So under the CRPC of 73, that period, which originally started with only 24 hours when it was first drafted, through a process of amendments because of the need of an investigating agency, went up to 15 days. And on the principle that an investigation has to be done with expedition immediately after the FIR is registered, the underlying jurisprudence was that the first 15 days is when the police will be doing their crucial investigations, and that's the time when they will need the custody of an accused. So the legislation said that 15 days is from the date of arrest you are entitled to police custody. We will not grant you more than that, because the approach was that it is well known in India, and there is enough material recorded in judgments and commission reports of the fact that when accused are in police custody, there is scope for torture and all kinds of violations of human rights. So the legislature said 15 days, but the first 15 days. What has now happened is that whilst they have retained the 15-day period, they've allowed that 15 days of police custody within the first 40 or 60 days of the investigation period. Possibly the reason for this is that in the recent past, one has seen that the accused have also abused this provision, because immediately on arrest, they go and get themselves admitted in hospital for the first 15 days, as a result of which the investigation is hampered. So therefore, from the perspective of the state and a good investigation, one can to some extent justify that this period of 15 days must be, some latitude should be given to an investigating agency to do it within the first 40 to 60 days. But I ask myself this question, that why is it that with greater degree of frequency, we now see accused running into a hospital for the first 15 days entirely? Why is it that is happening? And the concern is that accused are now afraid about their right to bail. We have over time now, and all the Chief Justices for the last 2 years have been very publicly trying to persuade the judiciary at the High Court, the subordinate judiciary, the magistrate, the sessions courts, to continuously remember that the law on bail is not changed. It's bail, not jail, and it's not the other way around, jail, not bail. And every effort is being made to convey the message But the unfortunate reality which you read about on a regular basis in the newspapers is that there is a fear that we have moved into the other regime of jail not bail. Now if this is the fear amongst the citizens or the accused, because there is a presumption of innocence with which we live, then the question is that if there is an abuse of the process so far as the state is concerned, then the accused are bound to find other stratagems in order to protect themselves, and therefore they say, I'd rather go into hospital because I'm not going to get any relief anywhere else. But if that relief was to be granted, I personally believe that you would not have seen as much of the misuse or abuse which one is now seeing about all these mechanisms of trying to stay away from a complete investigation. Because otherwise in the past we have often seen the accused were ready to cooperate. They would even go through a period of custody in the past because they were fairly comfortable that the principle of bail not jail was being implemented fairly regularly and frequently in cases. But since that has changed, you will find that accused are also now adopting this. So the question for, of course, at some point is that if we are able to bring back the principles of bail not jail, then did we really need a modification of these provisions regarding remand? And I think it was not necessary. It's a direction in which this legislation is moving. The second change that has been made is that when you grant a remand, after the police custody remand, there is a judicial custody. And the legislation now categorically is provided that judicial custody will only be in a prison or a reformatory or a borstar. This is now categorically provided in the Act. What does it do to judicial custody as we understand it today? It takes away the ability for a court to provide for hospital custody. So even after the police custody is over, we all understand medical treatment is a 21 right even for an accused. And therefore very often they are getting treatment in hospitals. And these are all treated as part of judicial custody because there are many government hospitals which have got judicial custody segments set up there. So that's part of that calculation of the period of detention that they have. But the moment you now specifically define only prison, all these hospital custodies are in jeopardy. We used to have what is known as custody parole. And a custody parole was when some accused had the need for visiting an ailing family member or an obsequial ceremony on account of a death or a marriage in the family, they would be taken out in custody and then brought back. Now that period of 2 or 3 days where they would be taken out is also technically gone because custody can only be prison. This whole concept of custody parole, which is now again in jeopardy. And the other one which is in jeopardy is where the Supreme Court, an extremely progressive approach to the criminal justice system, contemplated the concept of house arrest. And that also now is in jeopardy. So the concern we have is that whilst we provide for all this, we have impinged upon 21 rights of accused in relation to at least these 3 or 4 areas where you wonder what the courts are going to do. And across the country, each court will have a different interpretation of this provision saying, I'm sorry, I can't do it. So the question that comes to mind is that if they can't do it, what do? They grant bail or they refuse the 21 rights. Now you've left this again in the context of the criminal justice system to the individual judge to make up his mind as to what he should do. And I don't think that in the justice system, when you're dealing with accused rights, we should leave it to the hundreds of thousands of judges across the country who are at the grassroots level as a magistrate or as a session judge to keep interpreting this and create enough chaos and confusion. Give them the discretion to do what they think is right based upon the facts of a case. The moment you've taken away that discretion, you compel a certain outcome which may not be what the intention was, either which way. We then have another principle in default bail. So default bail is at 2 stages. One is at the initial stage when the charge sheet is not filed. There's not much change in that. But there was a separate default bail right that was introduced some years ago where prisoners who are under trials who are languishing in custody without their trials progressing were entitled to default bail if they had already spent up to half their maximum period of imprisonment in jail. In the earlier provision, the only exception was that if the offence was punishable with death, the provision doesn't apply. There's a logic to it, one can understand it. What they have now done is they have also added that offences which are punishable with life imprisonment fall outside of the scope of this provision. Now this has some very serious ramifications and implications, as I mentioned to you, that they've increased the number of offences where there's life till the remainder of your life. They've also increased the number of offences which have now got life imprisonment. And in all these cases, essentially, if the trial does not proceed, then these under trials languish in custody and this default bail right is taken away. We have in the penal code, in the Nyaya Sanhita, and this is something that I will have to get used to because I spent too many years calling it the penal code, but you all are at an advantage because you're going to start with this Nyaya Sanhita. But so in this Nyaya Sanhita, you will find that there are crimes of all types, which are the body crimes, the property crimes, crimes against administration, etc. And in all these crimes, we also see the misuse of provisions. I understand the body crimes are extremely serious, whether it's murder, whether it's sexual crimes against women, whether it's kidnapping, extremely serious. But you have a presumption of innocence, but all these offences are punishable with life. You take property crimes, and this is and in a city like Mumbai where you largely see more about property crime related offences, you all the time will see that criminal breach of trust and forgery are thrown at the accused in virtually every single case. And both these offences are punishable with life. So commercial disputes which land up in police stations, which have got punishments in life, you now find that it's outside of this second layer of default bail, and therefore they languish in custody in relation to a commercial dispute. So there's a challenge about some of this also. But it's an interesting thing because it's again about the quality of the drafting and probably the period within which these bills had to be finalized, is that it's possible that when the Nagrik Suraksha bill was prepared, they introduced the concept of life because at that time, the Nyaya Sanhita bill had redefined life imprisonment to mean life imprisonment is till the remainder of your life. This had some extraordinarily serious complexities because in the law as we have it today, granting life imprisonment which is till the remainder of your life was the discretion of the judge except in a handful of sections. You have now taken away that discretion also, in a sense, by saying that now we are giving this as a minimum. You should give some discretion to courts because they understand the facts of a case and decide which one. In fact, we had graded life imprisonment, which could have been 14 years, 20 years, 25 years, 30 years. The court could have the discretion to do it. I don't know how we are going to now see that play out in the context of the present legislation. But to come back to the issue, so when the bills were drafted, since the Nyaya Sanhita had life imprisonment till the remainder of your life, it's possible that in Nagrik Suraksha, they said that therefore there is no need, because it's virtually like a death sentence. Because if you're going to be there till the remainder of your life, it's as good as dying in jail. So you don't need to give them the default bail right. But fortunately, the Nyaya Sanhita in the final version of the bill which has now been passed, they changed that and brought the original definition of life imprisonment back. But having done so, they possibly forgot to change it in the Nagrik Sanhita is my sense. Because I can't imagine that you would exclude in the default bail right life imprisonment en masse. I think that's a challenge, and I think but we will again have to wait for some appropriate matter and a case to decide it. The other problematic area in the context of this default bail is that if there are multiple cases filed against an accused, then he is not entitled to the default bail. So whether he is in custody, not in custody, the moment there are multiple cases. So again, I give examples of Bombay city, Mumbai city, and the kind of commercial frauds that we see here. Take the problems of home buyers. It is very common that you will find a developer in multiple cases against a multiple set of home buyers, because each one goes and files his own FIR. Now the moment that happens, he is deprived of this default bail right. I don't think that could ever have been the intention, but it is certainly now there, and there are very serious consequences on this. So when you look at this whole facet of personal liberty in the Act, you sit back and reflect as to what is the direction of this new legislation. The only positives that I saw is that they've clarified what was the existing law, but as a matter of practice and procedure in trial courts was never being followed over the last 20-25 years, that if an accused is in police custody, the view of the judges was you can't apply for bail. At least now they've clarified that a bail application of an accused while in police custody cannot be rejected on the ground that he is only in police custody. So therefore it reinforces the original settled principle. So it gives you a little window, but not that it means you'll get bail. In the context of anticipatory bail, the shift again is that they brought back the provision of anticipatory bail which was pre-2005 amendment. So in 2005, when the CRPC was amended, they brought in various criteria for grant or rejection of bail. And the Maharashtra amendment insisted on the presence of an accused. And the provisos to the bill said, the amendment said, that if there is no interim stay, you could be arrested without a warrant. And if that anticipatory bail is rejected by the Sessions Court, you can be arrested. Now, fortunately, they've gone back to pre-2005, where these conditionalities are not there. And therefore, it opens up the ability to probably at least have the ability to go to a higher court without being arrested at the stage of anticipatory bail. These are small issues and what I might call crumbs which are given in the context of personal liberty. Let me therefore take you for a few minutes to speedy justice. Article 21 rights. So they have, in the procedure code, brought in timelines at various stages of investigation, inquiry, judgment, and mercy petition. You will find timelines for regular reporting of non-cognizable cases, medical examination reports to be filed before the magistrate in the context of when a person is arrested or if there's an inquest or if there's a victim of rape. Search records. So when there's a search, there's a requirement to file details of the search before a magistrate. Most of the times observed in the abuse. Now there are timelines which are specifically provided that this information must be filed with the magistrate. Attachment of property which affects the economic well-being of people and a country. So they have now provided for a show cause notice to be issued before the attachment of property. So that's a positive sign. There are timelines for committal, there are timelines for filing of a discharge application and framing of charge, there are timelines for filing plea bargaining applications, admission and denial of documents, and for rendering a judgment. And then, of course, in the context of the death penalty, mercy petitions at various levels. But the interesting, what I would call omission, is that many of these timelines are at the stage of initiation of the proceedings. There are virtually no timelines for completion of the proceedings. So there are no timelines for completion of an investigation. There are no timelines for completion of a trial. So, at one hand, we've talked about and we've seen the body of law on 21 rights of under trial prisoners, that the trial should be completed within a specified time. There's an opportunity to say that they should be trials should be completed within a specified time, except for reasons to be recorded in writing, but there can be complex cases which require more time. But at least the message to the system is that there's a timeline for trials. But there's obviously no provision for completion of trials. But what they've done is put an extraordinary burden on the trial judge to deliver a judgment within 30 days of completion of trial with a maximum period of 45 days. I think this is a serious disservice to the criminal justice system, because there are extraordinarily complex matters that go on with records which run into thousands and thousands of pages and hundreds of witnesses. And to expect a judge to complete the process of appreciation of evidence and render a judgment after reading these tens of thousands of pages and appreciating it properly and fairly, and rendering a judgment within 30 days and a maximum of 45 days of completion of trial, I think will have caused serious injustice, because a judge will find it extremely difficult to render his independent, unbiased assessment and appreciation of evidence in a matter like this. What happens to the quality of that judgment? When you push the subordinate judiciary to act in this manner. And I'm concerned that the quality of judgments, the quality of appreciation may be significantly impacted in this process. Take the terrorist cases, take the organized, they are running to thousands of pages to be analyzed and assessed. And a lot of this is about oral testimony, and in some cases about documents to be analyzed and understood whether it has been proved, it has not been proved. How will you see the circumstantial evidence? How will you appreciate it? Have you discharged the burden of proof? It's a very, very difficult task, and the subordinate judiciary is up to it. But to compel them to do this will cause significant injustice to the accused or the victim, as the case may be. So this is the challenge about timelines, and that's why I said optically good, but substantially I think we fall short when there's a need for ensuring that, because you can provide for additional judges, or you can provide an indication. Magistrates, you might say summary cases, because there are all types of cases. Summary cases, you might say 15 days. Summons cases, which are smaller, you might provide for 30 days, 45 days. Warrant procedure cases, you might say they're triable before magistrate, 45 days. Sessions trials, extremely complicated trials, how do you give them 45 days? Give them 60 days, give them 90 days, give them some period additional, if you want to put the timeline. But they've given a consistent position across the board. So this is on speedy justice. Before I come to other procedural provisions, let me tell you technology. So obviously, we live in a world of technology, so technology has to be provided for. So we have some interesting provisions of use of audio-video technology at the stage of investigation, where now searches have to be recorded through audio-video and furnished to a magistrate within a time frame. Trials, some of the statements also can be recorded through audio-video. Trials can be now conducted through audio-video. So, whilst we have this provision for audio-video, and which is a very positive movement, undoubtedly there will be a need, a significant need and a push for bringing in that technology into the subordinate judiciary, be it the magistrates court, sessions court. And now that you provided for it, how will you tackle a situation where the technology is not working? We see it on a daily basis. But anyway, this is progress, and we have to live with that progress, and therefore over time all this will work itself out. Investigations, again a positive, that they are now introduced more of forensic investigations so that the quality of investigations can significantly improve. And they are contemplating mobile forensic vans at virtually every district level, so that the forensic team can rush down to a crime scene and undertake an investigation with scientific methods which are today available. So that's a positive. The only challenge about this is that I don't think the country is anywhere geared up with those forensic vans, and it is going to take many years. And then the question is, it's for the states to actually provide for the forensic vans. So I don't know how each state is going to deal with it. But at a central level, as a legislation, very progressive, very positive. Smaller issues, they've introduced the concept of a zero FIR statutorily, though it was always there in law. Preliminary inquiries, they've again created a bit of an issue here. So whilst preliminary inquiry was ultimately settled by the Constitution bench in Lalita Kumari, and therefore examples were given, they've now, sorry to say this, but interfered in that Constitution bench approach. Because they now provide that a preliminary inquiry can be conducted for only certain types of offences which are punishable up to 7 years. So they made punishment the criteria for a preliminary inquiry and not the subject. So if there's a matrimonial dispute and if some offence is punishable with more than 7 years, then no preliminary inquiry. Commercial disputes, family disputes, as I told you, breach of trust, forgery, no preliminary inquiry. So now again created a huge corruption cases. Now Prevention of Corruption Act is 10 years, no preliminary inquiry. Now all this again is challenging because the principle of preliminary inquiry was never punishment based. It was always subject based. It was if there was a private dispute between parties and parties were misusing the criminal justice system by filing cases which were false, then it was for the police to make an assessment, is it a false case or it's a genuine case. And that is the reason why there was preliminary inquiry. But you've defeated that particular objective by saying that it is punishment based and not subject based. So that's the issue on preliminary. A very interesting change is about the participation of a proposed accused in a private complaint process. Very interesting. They now have provided that in case of a private complaint, when the verification is recorded and before the court issues process, notice is to be issued to the proposed accused. It's silent as to what is the scope of that inquiry, what are his rights as a proposed accused, but now a proposed accused can come in and object to the issuance of process. A series of judgments consistently took a view that a proposed accused has no locus at the initial stage of a proceeding, which is a matter between the complainant and the court. But we now have this introduced into the Act. It just takes me back that there used to be a practice, particularly in Bombay in the early part of the last century, in the 19, 20, 30, where magistrates actually used to follow this practice of issuing a notice, which was then commented upon by our High Court, which says that there is no provision in the CRPC and therefore that practice stopped. But interestingly now, it has now got statutory recognition in this particular version of the Act. The second area where there is an interesting development is for a public servant. So what we know as 156(3) today, which is now 174(5), if a private party files a complaint and wants an FIR registered against a public servant, the public servant is entitled to a notice before the order is passed. So that's another interesting development only in relation to public servant and 156(3). But I have not understood the rationale that in a private complaint you issue a notice to an accused, but when the private complainant wants an FIR to be registered and goes to a court for registering the FIR, there is a notice to a public servant, but there is no notice to another accused. So I have not understood the logic of giving him a right in that one proceeding, but not in the second proceeding. And 156(3) and now 174 has been talked about and also has been misused a lot in all these matters. There is a very serious provision which has been brought in some ways which I consider one of the most draconian provisions, is that there is a provision now for conducting a trial and conviction to be rendered against an accused in absentia. So whilst we always had a provision for trial in absentia because we wanted to protect the evidence of various witnesses till the accused actually is found and brought before the court, we can now actually convict him in absentia. And this has some serious due process concerns. And how do you sentence a man without being heard? To overcome this, there's a very interesting idea they brought about. They have said that the court will provide a legal aid lawyer to such an accused. But I've always struggled that in a criminal trial where witnesses have to be cross-examined, how does that legal aid lawyer get instructions on the defense that is to be proposed in relation to that case? But optically they've said, oh, we are providing for a lawyer. I think it doesn't serve the purpose. But someday, all of you will take it up somewhere, somebody will deal with it and see how it ties in with our constitutional rights. But it's there. Another missed opportunity is witness protection. There's a reference to it, enabling provision. This was an opportunity to actually provide for an entire witness protection program, but it's not done. There are several other points, but we will move to the next statute, which is the Bhartiya Nyaya Sanhita. So whilst I gave you a little jhalak about the punishment trend in this legislation, I sit back to wonder whether we have moved from reformative to retributive. Because commutation, power, the discretion has been significantly taken away. So whilst we currently had discretion that if there was commutation for an offence which was punishable where the sentence was death, there was a power in the government to commute to any extent. The section did not give any limits to the period for which it could be commuted. It could have been 14 years, 20 years, it could have been in a given extreme case even fine. Life imprisonment also, you can go down any period, including just fine. So the discretion that was vested in government in relation to commutation of all these offences has been significantly taken away, and now commutation is, if it is death, then you can commute only to life. Only to life. If it is life, you can commute only to 7 years. If it is up to 7 years, you can go up to fine. If it's RI, you can make it SI, simple imprisonment. But the question again is, we've lost faith in the authorities to apply their mind to a set of facts and apply appropriate sentencing depending on the facts of the case. This is the sense of the criminal justice system. This is the essence of that justice, that there are differing facts. There are differing states of mind which causes a person to do a particular act. And courts will take that into account when they do sentencing. But to take away that discretion is something which I think is a sign which is not very healthy, because we are losing the faith. You may have guidelines which might say that yes, in these kind of cases, which is there in so many GRs are there of various governments, which may give some general guidelines as to how you should exercise the power of commutation, exercise the power of remission. But do it through means of guidelines, because the guidelines can be modified with sets of facts. You may provide for alternatives, but to provide it in the statute with absoluteness as has been done, disables appropriate authorities and competent authorities from actually providing for guidance to the appropriate authority for how to exercise that power of commutation. In the realm of offences, just a few broad types of offences that I'll touch upon. One is crimes against women. So whilst there was an effort to make things progressive, so far as the rape provisions are concerned, they remain gendered, man against woman. They then brought in gender-neutral provisions, but some of them, which is assault and use of criminal force, voyeurism, insulting modesty, sexual intercourse by deceitful means. And in all these, the offender can be a man or a woman, the victim is always a woman. So they in a sense made that gender neutral relatively, so far the offender is concerned. But the question for us at this stage is that in the post 377 era in which we live, and I must tell you that 377 has not been brought back into this statute. In the post 377 era, where in the context of criminal law, we brought in an element of gender neutrality in the relation to sexual relationships between consenting adults, why could we not have made this entire body of law gender neutral? It coincides with the larger proposition and principle of saying that 377 is no longer an offence, but force for sexual activity will continue to be an offence, but it should always also be gender neutral. So that's the opportunity, if I might say, was lost while trying to make provisions gender neutral. The one positive is, of course, they've increased the age of consent for a married child to 18. Earlier it was 15. But again, this is unfortunately, when you look at legislations and you don't know who's drafting them, you tend to miss out some provisions which create problems of irreconcilability. So there is a provision which is in section 98, which was already there in the existing penal code also, which actually permits illicit intercourse with a child is prohibited, but the explanation says that this provision will not apply if that illicit intercourse is with a married person. So what it essentially has done is, by the explanation, it has allowed illicit intercourse with a underage girl. So when you contrast this provision with the provision of rape, where there's a concept of statutory rape, you find that the two are directly in contradiction with each other. Now maybe it was missed, and I can hope that somebody hears this and actually removes that particular provision from the statute to avoid this particular confusion and conflict. But it's very much there. The other one which obviously they have chosen not to deal with is the marital rape exception pending in the Supreme Court insofar as the present law is concerned, but they've continued with that as an exception. It's also an indication as to what would be the status of a woman in a marriage even now. They've introduced a specific offence of promise to marry and all forms of promises for the purpose of sexual intercourse. So marriage is one, promotion is another. They've introduced that as a specific offence. Earlier, it was being brought through by means of interpreting section 90 of the Act, which deals with consent, and said that any consent by deceitful means cannot be consent in the eyes of law. But now they've actually provided for it. So that's all right. This is broadly on crimes against women. The other one that they've brought, which is again a very significant change, is to bring in terrorism and organized crime into the Nyaya Sanhita. So whilst in terrorism, they've picked up the same definition which is in the UAPA, they've not picked up the definition of economic security which is in the UAPA. And the economic security in the UAPA has been given a restricted meaning through means of interpretation by various high courts. But this definition is not part of this provision here. And I worry as to what it would mean when you deal with economic security and terrorism, which is now come into the Nyaya Sanhita, which is a law which can be implemented by the local police station across the country and not by a special investigating force like the NIA. So what happens to the principle of economic security? And in today's world, what we read about, is just to give you a stark example, is that the provisions of the Money Laundering Act have been interpreted by the Supreme Court to mean that this law is for the benefit of the economic security of the nation. So the question that troubles me is that a very ingenious complainant can possibly invoke the provisions of terrorism even in commercial disputes and money laundering cases. If the definition was restricted as it was done under the UAPA, it was consistent with the object of that legislation. But we don't understand as to why that UAPA provision has been now introduced in the Nyaya Sanhita. Similar is the case with organized crime. The organized crime had a special legislation in various states. We were the pioneers as a state with the Maharashtra Control of Organized Crime Act. The same definition is picked up and put in this central legislation, but one doesn't understand what the significance of that is. Are they therefore wanting to now, over a period of time, consolidate all these into one central legislation, in which case will UAPA be repealed? Will the states be asked to repeal the state legislations, or the doctrine of repugnancy will start coming in, and this will be argued in courts as to whether the central legislation will survive or the state legislation will continue, is again a matter of debate. But there is nothing in the notes on clauses or debates, well, there were no debates, to actually indicate as to why these provisions have been brought into the Nyaya Sanhita. The pluses and minuses of bringing it into the Nyaya Sanhita. The special procedural provisions which facilitated these investigations, which were there in both the legislations in the context of collection of evidence, even a statement of a co-accused, admissible in certain circumstances, etc., all of which doesn't find place in the Suraksha, Nagrik Suraksha provisions. So, what does it do to an investigation? Because all those were special powers, used very well, and particularly in these kind of very serious crimes, necessary. And therefore, in many cases where the Supreme Court had occasion to deal with the virus of the provisions, upheld it. But I don't know whether it was lost sight of, what was it, or will come in by a new legislation, no idea. But that's gone. But on the flip side, what is also gone is, what is well known in our language is the twin conditions on bail. So both these legislations had twin conditions on bail like the Money Laundering Act. Now bail will be considered under provisions of the Nagrik Sanhita, in which case the twin condition principle will not apply to terrorism and organized crime. I don't know whether that's good or bad when you're dealing with these kind of matters, but in some of the organized crime cases, they are not necessarily syndicates and gangsters who are involved. They're just people with two charge sheets against them, satisfy the condition, and commercial disputes are often relegated to the realm of the MCOCA. Which is the same thing that will happen here. And this, the difference is that in the context of the MCOCA, there are senior officers, designated officers who are to conduct those investigations. That is not provided for here, and therefore it is the ordinary police inspector at the local police station who can also start this entire process. So very serious ramifications also there. Sedition, of course, captures the imagination of the country because all about Article 19, etc. If you actually see the provisions, the language change that has happened is disaffection to the government of the day is removed. But if we analyze what is disaffection and look at it in the context of various judgments, many of those elements of disaffection, without using the term disaffection, have been found their way into this new act. So somebody has very artfully drafted that section to actually provide essentially. So we'll have to wait for a court to rule on what will be the actual term, meaning of these various terms. And then takes me to Sakshya Adhinayam. I'm just giving you a very broad perspective. There's a lot of stuff which has happened in between, but Sakshya Adhinayam. In Sakshya Adhinayam, this was the one legislation which, in the context of where we are with evidence, needed some significant thinking. We are all in the world of digital evidence, electronic evidence. Has this act done enough to actually articulate adequately how the digital and electronic evidence will be proved? And how do you deal with fabricated digital and electronic evidence? I think you people understand more than me. it just befuddles me every day when I read what's going on in the way evidence is just getting created. But you people will understand it better than me, that it is today seems to be the easiest thing to do is to fabricate evidence online, whether it is your handwriting, whether it is your biometrics, whether it is your voice, your deepfake story which we are reading about. Anything and everything can be fabricated with ease. And it is extremely difficult for the traditional experts to come and say that no, this is not your handwriting or this is not your biometric, etc. How are we now going to deal with this problem? Whilst the Ministry of Information Technology, we are waiting for the rules on deepfakes, the sense I get is that they will only hold the service providers responsible and liable in relation to deepfakes and the like. But in a criminal investigation, that is at a administrative level, if I may use that. But in the context of a criminal investigation, how do you deal with this? How does a local police officer understand that this is genuine or not genuine? Do we have sufficient wherewithal? Do we have the technological inputs under the Evidence Act? It is very easy these days to actually deal with this kind of evidence and say that this is not proved adequately. And more so in today's time when we can see today the example of Sachin Tendulkar. I mean, these kind of things are happening, and I must only tell there's one live example which we had argued in the Calcutta High Court about 7 years ago about how do you prove deepfakes, because the issue was about how you control the digital evidence. So the effort is to try and ensure that the digital evidence, the custody of the digital evidence, the original digital evidence is properly maintained. Do we have enough checks and balances in order to ensure the custody of the original digital evidence? And what the Evidence Act, the Sakshya Adhinayam has done is it has brought back 65B as the primary basis on which you can prove the digital evidence. Now 65B came in for debate and discussion in the Supreme Court, and the earlier view, I think that was Aslam's case, Anwar's case. Anwar was the first and Arjun is the second. So Anwar's case took a view that the only means by which you can prove a digital evidence is 65B certificate. Arjun's case, recognizing the limitations of such a view, allowed independent primary evidence to be led in relation to the device. But it would appear from this change that has come in now that we have gone back to the Anwar case. And if you carefully look at Arjun's case recognizes the problems of digital evidence. Essentially, it says all digital evidence is all stored in zeros and ones. And therefore, there's always a scope for manipulation and fabrication. So far as other forms of evidence were concerned, it was in analog form. And the analog form could not be tampered with. And that is the reason why they went back and said we can also consider needing primary evidence. But we now seem to have gone back to the equivalent of the 65B. So we'll see how this evolves. We will hope and pray that some of this will be modified, or if not modified, then courts will have to step in and ensure that. So what is the kind of takeaway that we have? Is I think in the Nyaya Sanhita, I think the one area which I think was necessary is to bring in more offences in the area of technology, directly and specifically. So whilst we have lived in the physical world all this while, and these offences were all in the context of the physical world offences, we now are actually in a phygital world, which is physical and digital. And a lot of things are happening purely in the digital world. So the need was there to actually bring in an entire code on offences which are specifically linked to the digital world. And that, even if it's the same, it may be a breach of trust, it may be, in fact, it's a very interesting thing, is you might have read in the newspapers, what the experiment in the United Kingdom is that whether a rape of an avatar in Meta world can be constituted as an offense of rape. Why? Because it impacted the psychology and the well-being of the girl whose avatar was gang raped in the virtual space. Now, it's a very, very fascinating evolution of where the law is, but that is where the world is moving. And if this is where the world is moving, and we had the opportunity of building in a legislation which will keep us going for the next 50, 70 years, then was that this the opportunity to bring in these kind of elements into the Nyaya Sanhita? Because the younger generation understands all of this, and this is reality of the world today. There are several other misses, but I think I've exhausted my hour and tried to fulfill the desire of my colleagues here to give a very broad brush overview. There's a lot that can be said. The youngsters have given me many more points. Mr. Moore has sent me a note on what I should talk about. But I think that we can keep debating and discussing various other nuances of these bills as time passes. But thank you very much for this opportunity to the Bombay Bar, for all of you to come in and listen in on my views on these 3 new bills at this point. Thank you very much. Thanks.
Concludes our function. We have our tea and snacks. Please join us for the same. Thank you.